Hello, everyone. Welcome to the 18th International Conference on Artificial Intelligence and Law. I am Poliana de Queixe, and this is the third panel of the third day of the event. Also, in the name of the conference organization, I'd like to thank our platinum sponsors, JUS Brazil and Albert Einstein Israeli Hospital, our gold sponsors, Logarithm, Legal Code, and PG Lawyers, and our silver sponsors, Urbano Vitalino Lawyers, Opsibum Lawyers, and Oasis Open. The first one to present is Mr. Alexander from Poland. The word is yours.
Thank you. So let me share my screen. Can you see my screen?
Yes.
Okay, so I will give you a presentation entitled Automatic Extraction of Amendments from Polish Statutory Law, which was a collaborative work between me, Mateusz Piech, Zbigniew Kaleta, and Krzysztof Wróbel. Three of us work at the AGH University of Science and Technology, and Krzysztof
This meeting is being recorded.
Works at the Jagiellonian University. So the agenda is really quick. I will start with the amendment in Polish law, then the annotation procedure, the approach we apply to extracting these amendments, the experiments, and I will reach the conclusion. So to give you some context, we are working on a LEMKIN, an intelligent legal information system, which will provide question answering in the domain of Polish statutory law. And so we have to access the most recent regulations because the law in Poland changes very often. So, and the other problem is that the consolidated texts are published, but only once or twice a year. And the laws are distributed only as PDF. So we can look at these documents as semi-structured data. So to give you some numbers, for instance, in 2019, there were 20,000 pages of new laws enacted in Poland. So this is a very large number. So I think that doing that manually, processing these amendments manually is not an option. So we have developed this amendments pipeline, which includes four stages. Amendment span detection. Then when we detect the spans, we interpret this spans. Then we also have to detect the spans related to the dates when is the application of given amendment, and then we have to interpret these dates. So this presentation concentrates only on the third step, so the amendment span detection. Here you have an example of an amendment definition in the bill. Blah blah blah. The following amendments are introduced. For instance, in Article 20, paragraph 2b, in the introduction to the enumeration, the words paragraph 2 are replaced by paragraph 2a. Okay, these are the amendments we have in Poland. So, and you can see that we have some specific items here or entities. For instance, the location of the amendment, the identification of the old content of the provision, the new content of the provision, as well as the type of amendment. So let's now move to the annotation procedure. And let's start with the annotation types. So we have identified three groups of spans. The first group is amendment type. We have content addition, content removal, content change, as well as unit addition, unit removal, and unit change. The difference here is that in the first case, the content is changed. The content inside the provision is changed. In the other three types of amendments, we have the full unit. The full unit is changed in some way. And also we have change ID, which is not, I don't think it's very common in literature. So this is something which is, let's say, discovered. The second group of annotations are identifiers. We have a new ID, amended ID, and preceding ID. Usually, the most important thing is the amended ID, but if you provide a new unit, you have to identify the preceding ID. And also we have the last group is the content. And you have, as you have seen, for instance, we have the old content and the new content. Also, in some cases, there's the preceding content. So these are the types of annotation we have identified. And regarding the data set which was annotated, there were more than 240 bills of Polish statutory law from the years 1998 2018. This data set was split into train, development, and test sets in proportion 10-10. And the documents were not divided. We kept the documents in specific part of the data set. And the statistics are as follows. We have more than 400,000 tokens. More than 200,000 tokens didn't receive any annotations because we thought that it is not necessary to annotate them. On the other hand, almost half of the remaining tokens received some kind of annotation. And when we look at the amendment types, roughly, we have identified roughly 5,000 amendments in this bill, which I think is quite a large number. Okay, so let's move to the approaches we have applied to this problem. So the first thing we did with the documents were pre-processing. Because we wanted to apply the family of BERT models, we have to somehow fix the problem of the 512 subtoken limit. So first of all, we try to just use the documents as they are and use only the 500 tokens which are at the beginning of the document. But it turned out that such an approach, first of all, gives very low coverage. It only covered like 40% of the documents. And the other problem was that the numbers were very low, especially the micro F1 measure was quite low. So at the second approach, we split the sentences using a library devoted to Slavic languages. So it gave us 100% coverage. And in these preliminary experiments, we observed 94% macro F1 and 84% micro F1, which was still too low for our expectations. So we have devised more sophisticated pre-processing. We split by sentence, but not inside a span. If the sentence was split inside one span, it was not this span was not divided, but this procedure could be only applied to the training data. So during inference, we split by the smallest part of a provision. The provisions are structured so, and you can identify the lowest level of this provision. So during inference, we apply the model to this smallest part of a provision. So the models we have used, first of all, we used a very simple approach based on regular expressions. So this is the rule-based approach. Then we used a family of BERT-based models, Roberta, which is the English Roberta, XLMR, which is a multilingual BERT, and Herbert is a Polish version of Roberta, so to say. And as a last model, we used RNN, so recurrent neural network. Actually, we used the FLAIR library. So regarding the rules, what we can say about the you can see all the rules we have applied, which are very short, and we think this is the biggest advantage of this approach. But the problem is that we couldn't identify a rule for the preceding content tag. As well, we have like a large number of false positive, especially related to the IDs, because the IDs can be part of the amendment definition, but these IDs can be also in the content of the amendment. So this approach is not very general. Then the Byron model, it was based on the character level language model. So the model was trained to predict the next character in the text, and it was combined with the token level language sequence labeling model. So this is the approach used in FLAIR, and we provided two versions of this, one trained on the sentence split, and the second trained on the optimized segmentation. And the last one, the last family of models were, as I said, was BERT, Roberta, XLMR, and Herbert. I won't get into the transformer architecture because I think that there was so much time already spent discussing BERT. So I will move to the next slide. So the experiments. These are the results of our experiments. The best results were obtained using the BiRNN approach, but let's first look at the rules. As you can see, the micro, macro, and weighted F1 scores are pretty low for this approach, so this justifies our machine learning approach. Then when you look at the BERT-based models, we can see that the Roberta model, which was developed for English, not for Polish, gave the best results, which is a kind of a surprise. And the last observation is the fact that the BiRNN model gave the best results, which are almost perfect in this setting. So to explain the probable reason for that is no hyperparameter optimization for the BERT models. And we know that the hyperparameters are usually crucial for obtaining very good results. But we thought that it's not, because the results were so high for the BiRNN model, and all of these experiments were run with the default parameters, we thought that it's not necessary to try to find the best hyperparameter combination. So to conclude the presentation, the recurrent neural network turned out to be the best. The neural network models work better than the handcrafted rules, which is kind of obvious. But what is crucial here is the pre-processing. As you have seen, if not some special pre-processing was applied to the documents, the results would be much worse. And what was not presented is the part related to the interpretation of these spans, but we have already implemented such an algorithm, which is very simple, and it produces very good definitions of the amendments, which can be applied directly to the text. And my general idea, which might be a bit controversial, is that to make the neural network model do the smallest task, which is hard to code, and then let the algorithm do the rest. This is like an opposition of this end-to-end approach. I think that it's much easier than to interpret the processing of the whole solution than in the case when you try to learn the model end to end. So thank you for your attention, and I'm waiting for the questions.
Thank you, Mr. Alexander. I have one question for you. Yes. At the end of the paper, you say that a problem related to the topic of the paper is the detection and processing of temporal expressions that determine the date of application of a certain additive. How do you think this issue could be solved? Okay, so I put this can be resolved in two stages. The first stage is detection of the spans, as you can see here, right? So this spans, this structure of the definition of the application date is it is well structured. It is well structured, not very well structured, but it's quite well structured. But then you have to apply some interpretation algorithm. So for now, I don't have a direct resolution for that, but for sure, I would apply some kind of temporal logic model, temporal logic inference engine to resolve this problem. I don't think that using neural networks for that makes sense. Okay. Thank you, Mr. Alexander. The next one to present is Mr. Marzi from Spain. Mrs. Marzi, sorry, from Spain.
Hello, my name is Marzi. I am a PhD student from Pompeu Fabra University. In this paper, we studied how machine learning may be used to increase the effectiveness. Sorry, can you hear or not?
Yes.
Okay, just checking.
Mrs. Marzi, I think it should be have a sound.
Yes, because of that,
No.
I asked for that. Yeah, I will share it again. I think I forgot to tick the sound share.
Okay.
Hello, my name is Marzi. I am a PhD student from Pompeu Fabra University. In this paper, we studied how machine learning may be used to increase the effectiveness of a criminal recidivism risk assessment tool named RiskCanvy without introducing undue biases. RiskCanvy is a risk assessment tool that was introduced as a multi-level risk assessment protocol for violence prevention in the Catalan prison system in 2009. This protocol is applied multiple times during an inmate's period in prison. The official recommendation is to do RiskCanvy evaluations every 6 months. In each RiskCanvy evaluation, the inmate is interviewed by professionals, and risk is determined for the inmate relative to some outcomes: self-directed violence, violence in the prison facilities, committing further violent offenses, breaking prison permits, and a fifth score that was introduced more recently for general recidivism. In this study, our aim is to obtain more efficient and fair recidivism risk assessment tool. So let's review algorithmic fairness in some risk assessment tools so far. In seminal research done by investigative journalism organization ProPublica, it was concluded that the widely used COMPASS risk assessment tool is biased against African American defendants. A follow-up study analyzed the fairness of COMPASS in terms of predictive parity and found that COMPASS outcomes systematically overpredict risk for women, thereby indicating systemic gender bias. However, the findings of the ProPublica study were rejected by Northpoint, the COMPASS developer, claiming their algorithm is fair because it is well calibrated. And in this report, it is shown that the COMPASS risk scales exhibits accuracy, equity, and predictive parity. In comparison, other studies have shown that some risk assessment tools, such as the PCRA, SAVRI, and the YLS CMI, do not exhibit racial bias in the recidivism prediction. Also, in a study focused on SAVRI, it is shown that although ML models could be more accurate than the simple summation used to compute SAVRI scores, they would introduce discrimination against some groups of defendants. In general, it is impossible to maximize fairness and accuracy at the same time. Also, there are many different definitions of algorithmic fairness, some of which are incompatible with one another. It is impossible to satisfy all of them simultaneously, hence there are necessary trade-offs between different metrics. In this regard, some studies try to mitigate potential algorithmic discrimination by satisfying equalized odds, or in other words, avoiding disparate mistreatment along different sensitive groups. In addition, due to the importance of the calibration in risk assessment tools, some previous work has also tried to minimize error disparity across groups while maintaining calibrated probability estimates. So in this work, to see the effectiveness of machine learning in comparison to the risk-can-be protocol, we obtained a ML-based model to predict violent and general recidivism using some features consisting of demographics, which is gender, nationality, and age at the time of the last evaluation, a subset of selected risk items of the risk-can-be evaluation using a feature selection method, and the average violent recidivism or general recidivism score from the first to the last risk-can-be evaluation. So results in terms of AUC error rates, GFNR and GFPR are presented and compared with the existing risk-can-be protocol in this table for both violent and general recidivism prediction. So according to these results, ML models with an AUC of 0.76 and 0.73 shows more accuracy compared to risk-can-be protocol in predicting violent and general recidivism. And however, the difference is very small between the accuracy of ML models and risk-can-be, and it is surprising considering that risk-can-be was not computationally optimized for predictive accuracy. As well, ML models show less error rates in terms of generalized false positive rate and generalized false negative rate, and more F score compared to the risk-can-be. By GFPR, or generalized false positive rate, we mean the probability of detecting recidivism for the cases who do not recidivate, and GFNR, or generalized false negative rate, means probability of failing to detect recidivism risk for cases who do recidivate. Then, by fairness analysis of the models, we show that algorithmic discrimination can easily be introduced between groups such as national versus foreigner or young versus old. So in the result table here, we can see biases in colored circles, as can be seen in both general and violent recidivism predictions. There are more disparities in terms of GFPR error, which are shown in red circles, compared to other metrics. So in order to mitigate this bias, we applied a method in which a single error disparity in terms of GFPR is minimized, while calibration is maintained across groups. Calibration means that the output of the classifier is not merely a score, but an estimate of the probability of the outcome. When we talk about fairness across two groups, it is important that this calibration condition holds for the cases within each of these groups as well. Because if the risk tool is not calibrated with respect to different groups, then the same risk estimates carries a different meaning and cannot be interpreted equally for different groups. So here we can see the results. Obtained results show that the bias mitigation procedure can reduce GFPR disparities across groups. So as a conclusion, we can say that using ML-based models in this study, we obtained a slightly more accurate results compared to risk-can-be. Although this improvement in accuracy by ML model would be insufficient on its own to support its introduction as a risk assessment tool, a key element of ML models is their flexibility. An ML model can be retrained with newer data and incorporate new factors as the population of inmates changes and more data on recidivism becomes available. So then we analyzed algorithmic fairness of the models and found some disparities in terms of GFPR. By studying differential treatment of risk-can-be and ML models across different groups, it can be stated that depending on the desired metric and groups, machine learning and human expert can lead to different but comparable results. An advantage of ML model is that the emphasis on different metrics can be changed during the modeling as legal or policy changes are introduced. Then using a bias mitigation method, we could minimize GFPR biases while calibration was maintained across groups. Finally, when introducing ML-based risk prediction in an application, improvements in accuracy need to be carefully contrasted with potential algorithmic discrimination, and it is very important to apply algorithmic bias mitigation procedures to minimize the disparities across groups. Thank you.
Thank you, Mrs. Marzi. We have a question here for you. Do you think the AI regulatory framework proposed by the European Commission last April could affect the application of your model?
You mean if with respect to fairness, you mean the fairness definitions? Yes. I don't know if this question is related to the fairness definition of GDPR.
The only information that I have is the one that they sent me. So you can comment about it. You don't have to specifically answer this question.
Yes. So yes, yes, it is. Generally, it is because one of the most important things regarding algorithm and machine learning in society is this considering this discrimination that is inside the algorithms. So this is one of the important things that, and the GDPR considers this a lot. And but the thing is that something is different, not different, but in computer science, which is my field, in comparison to law, we have the same meanings, but with different definitions in fairness. So maybe the expressions should have a common language in both law and computer science, but the goal and the aim is the same. When the meaning and concept is the same, but some common language should connect them together, like computer science and law expressions.
Okay, thank you, Marzi.
You're welcome.
Now we will have the streaming of the paper Converting Copyright Legislation into Machine Executable Code, Interpretation, Coding Validation, and Legal Alignment. After the streaming, Mr. Guido from Australia will answer some questions.
That you can see my screen. Yep, okay, I'm going to proceed. Oh, great, thank you. Okay, so hello everyone, my name is Alice Whitt. I'm a postdoctoral research fellow in the School of Law at the Queensland University of Technology in Brisbane, Australia. And it's a pleasure to be presenting the full paper that I've co-authored with Associate Professor Anna Huggins, Professor Guido Governatori, and Joshua Buckley. So this paper presents what is, to the best of our knowledge, a first of its kind experiment that aims to shed light on how different legally trained people interpret and convert Australian Commonwealth legislation into machine executable code. So first, I'll briefly provide some background information, and then I'll explain why we focused on Australian copyright law. Next, I'll outline our experiment design and methodology, then some results, and I'll finish up with some concluding remarks and, of course, questions. So first, I just wanted to situate this experiment within the burgeoning Rules as Code movement, a label for diverse initiatives that reevaluate how, when, and for whom government rules are made. So there are two main Rules as Code approaches to date. The first of which involves converting existing regulation, including statutes, into machine executable code so that computers can read it and then use it to carry out programs. The second approach involves co-drafting regulation in both natural language and machine consumable format at the same time to enable computers to model the effect of the law. So while decades of research inform these overlapping areas and countries including Australia, New Zealand, France, and Canada have made significant inroads with the practical Rules as Code movement, challenges persist in ensuring that encoded rules are transparent, traceable, appealable, and what we focus on in this experiment, legally accurate. So against this backdrop, last year, we commenced a multidisciplinary and collaborative research project that seeks to identify the legal and the coding challenges of converting Australian statutes into computer code, research that largely falls within the first rules as code approach, given that we're focusing on existing legislation. So the copyright law experiment that I'm walking you through now today falls under the third phase of this broader research project. So please do look out for our forthcoming publications relating to our other encoding exercises. So, as mentioned, the focus of this experiment is on copyright law, a body of intellectual property that confers rights in relation to the reproduction and dissemination of material that expresses ideas or information. So specifically, participants interpreted select provisions of the Copyright Act 1968. Periodically, I'll refer to this as the CA or the Act. And as part of this, we focused on literary, dramatic, musical, or artistic works known as Part 3 works. So we focus on copyright law for several reasons, including our research team having some copyright law expertise, and because this body of law is widely applicable to a range of stakeholders, but often difficult for lay audiences to understand. In practical terms, our research could be of benefit to large technology companies, galleries, libraries, educational institutions, and archives that often deal with copyright issues in bulk. It could also potentially benefit a large range of smaller content creators who routinely rely on existing material. So in research terms, by generating new knowledge, particularly relevant to the first rules as code approach, we can contribute, or we aim to contribute, to the rules as code movement more broadly. So we conducted this experiment over a 2-week period in late 2020. The population for this experiment was the pool of legally trained research assistants attached to the broader research project. So in this preliminary study, we had 3 participants in total, and I'll call these participants P1, P2, and P3 throughout this presentation. So in week 2, or phase 1, the participants independently coded sections 40, 41, 41A, and 42 of the Copyright Act, which are among several fair dealing exceptions to copyright infringement. So these exceptions are those for the purpose of research or study, criticism or review, parody or satire, and reporting the news respectively. So by independent coding, we mean that participants worked in remote coding files rather than the project's shared GitHub repository. Additionally, we instructed participants to assume that the elements for determining whether copyright subsists in a work are satisfied. So we asked them to assume copyright subsistence and to encode the select legislative provisions only. So this means they did not encode the relevant case law, and this was largely due to time constraints. In week 2, or phase 2, participants encoded sections 31, 32, and 36 of the Copyright Act. These provisions outline the nature of copyright in original works in which copyright subsists, and infringement by doing acts comprised in the copyright, respectively. So like in week 1, participants encoded the select provisions only, so they didn't encode the case law. Aside from participants encoding different provisions in each phase or each week, which was a choice that we made largely to avoid participants becoming overly familiar with the statutory text, the main difference between the 2 phases is that week 2 had an intervention, a 2-hour compulsory meeting during which participants collaboratively drafted key atoms or legal terms for manual coding, and they did this in a single remote atom or coding file. The agreed atom file was separate from our other established coding conventions, and after this meeting, participants independently coded the select provisions like in week 1. And participants could refer back to, but they couldn't edit those agreed atoms. So the purpose of this intervention was to test our hypothesis that coders collaboratively agreeing on key atoms or legal terms before commencing independent coding work can increase the similarity of their coded output. And our null hypothesis was the opposite. So to convert select provisions of the Copyright Act into machine executable code, participants used the coding language Turnip, which coders can run via the online environment Turnip box as shown on the top right-hand side of the screen. As I'm sure that many of you might know, Turnip is a programming implementation of defeasible deontic logic, which our collaborator, Professor Guido Governatori, will explain in the next presentation. So I'm not going to go into these technical specifics here. But suffice it to say that we adopted this language because it's particularly useful for coders attempting to express complex rule structures, and in particular, it enables coders to model deontic concepts such as obligations, permissions, prohibitions, and exemptions, which are often present in legislation and were present in the Copyright Act. Also, defeasible deontic logic has been applied in several studies that aim to convert different types of Australian regulation into computer code, and some of those are listed on the screen there. I also wanted to flag that earlier this year, Guido and I put together a masterclass that outlines some of these technical specifics in more detail, and that masterclass you can find on YouTube, as you can see there on the screen. So an important part of this experiment and our methodology for converting legislation into machine executable code more broadly is measuring the accuracy of encoded rules in terms of coding validation and what we call legal alignment. Now, these processes are distinct, but both critically important in our view in enhancing the accuracy of encoded rules. So coding validation on the one hand focuses on whether encoded rules adhere in a formal sense to the select coding language and relevant coding conventions. In practical terms, this means that the code runs and it produces a definitive outcome. Coding validation is also concerned with the degree of internal consistency between coders to ensure that the various encoded rules work together as a cohesive whole. Our coding validation processes involved automated and manual analyses of encoded rules. For automated analysis, we created a program that uses string manipulation to parse each participant's atoms into string arrays and then compare the participants' encoded rules to find similarities between their approaches. We also manually cleaned some aspects of the participants' coding files to attempt to enhance the comparability of their rules. For example, we adjusted some atom names, which used a mixture of periods and camel case in line with our project-specific naming conventions. On the other hand, legal alignment is concerned with enhancing the congruence between the encoded rules and the true meaning of the select regulation, for example, legislation. And this is an undertaking that heavily relies on human judgment. Our legal alignment process is based on what's called the modern approach to statutory interpretation, and it incorporates the Turnip coding language. So a good question here is, why do we conceptualize legal alignment in terms of the modern approach? Well, the modern approach is the interpretive approach currently favoured by Australian courts. In the Australian legal system, the challenge of enhancing legal accuracy of encoded rules, as I mentioned earlier, is made more complex by the strict separation of judicial, legislative, and executive powers in the Constitution, under which only the judiciary can authoritatively interpret the meaning of statutes. So the separation of powers, of course, is not unique to Australia, but the Australian courts have adopted a fairly strict approach, and therefore it's best practice for interpreters, including those attempting to do the conversion work like we did, to adopt this approach and apply it from day one. So as you can see on the screen, Project Blue Sky and Australian Broadcasting Authority provides the leading articulation of the modern approach, which is expressed in very clear terms there on the screen. To summarise, this modern approach requires an interpreter to analyse the text, that is the statutory text, the context of the legislation, and the purpose or the policy of the legislation that they're seeking to encode. And most importantly, this approach has taken courts in Australia away from the previous literal or so-called objective or plain meaning approach to interpretation in favour of a more nuanced contextual approach to statutory interpretation. So what we ended up with is a 7-step legal alignment process, as you can see on the screen, that fuses the modern approach to statutory interpretation with Turnip. Now, these seven steps, we don't have time to go through all of these in specific detail, but suffice it to say, as you can see on the screen, step 1 starts with the text, step 2 goes to the context of the legislation, step 3, interpreters consider Parliament's purpose in enacting the legislation. Step 4 is where interpreters evaluate the interpretive choices. Step 5, where you consider canons of construction, including syntactical and statutory canons of construction, which help coders address ambiguities in the text. Step 6, coders return to the provision and start the manual conversion work. And in step 7, coders undertake acceptance testing of encoded provisions. Now, if you'd like to see this, of course, in more detail, please do take a look at our paper. Now, in general, we argue that the 7-step process provides a very useful guiding framework that is adaptable and overall can enhance the accuracy of encoded rules. Now, before I delve into our results, of course, there are several limitations that we need to keep in mind, but in the interest of time, I'll just say that the foremost limitation, of course, is our limited number of participants, but we will be addressing this with further research that expands upon this experiment. So overall, the results of our automated analysis show a significant increase in the similarity of atoms and shared rules drafted by participants after the week 2 intervention, as illustrated in Table 1. More specifically, in Table 2, you can see that the similarity of atoms increased from an average of 4.7% in Phase 1 to 57% in Phase 2. The similarity of rules drafted by participants also increased, albeit marginally, from 0% in Phase 1 to 1% in Phase 2. Now, these results overall support our hypothesis that participants agreeing on key atoms or legal terms before commencing individual coding work can increase the similarity of their encoding choices. And importantly, as individual participants encoded different statutory provisions in weeks 1 and 2, this cannot simply be attributed to coders' increasing familiarity with the statutory text. So despite these notable increases in the similarity of atoms and rules from week 1 to week 2, the results show that participants continued to make a range of divergent interpretive choices, for which there are 3 main explanations. The first is the relative difficulty of applying the modern approach to statutory interpretation, which, as previously explained, involves deriving the meaning of a text from close examination of the statute, context, and the purpose. As the Honourable Justice Michael Kirby, a former Justice of the Australian High Court, contends, the task of construing statutory language is notorious for generating opposing answers, none of which are indisputably correct unless the courts have reached definitive conclusions about, for instance, what different provisions mean and how they apply in different cases. So given the potential margin for error in interpreting the meaning of statutory language, it's unsurprising that there were still differences in the encoder's interpretive choices. So second, we also observed participants encoded the select provisions with varying levels of granularity. And by granularity, we mean the extent to which coders split or broke down the statutory text into discrete parts. So take, for example, the atoms on the top right-hand side of the screen that participants created for Section 40 of the Copyright Act that establishes a fair dealing exception to copyright infringement for the purposes of research or study. So here you can see that P1 or participant 1 adopted a high-level approach that combines research and study into one atom, while P3 uses multiple fine-grained atoms that distinguish between research or study. So in general, we advocate for a more fine-grained approach that provides as much detail as possible, as you can see in P3's approach there. But as the results illustrate, participants, despite being from the same team, adopted different levels of granularity. Now, another possible explanation for the differences that we observed is that coders can use the Turnip language in different ways to achieve the same outcomes. So an interesting example comes from week 2 of the experiment, where participants encoded section 31(1)(c) of the Copyright Act on the bottom right-hand side of the screen. So this provision establishes that copyright in a literary work, a musical or dramatic work, is an exclusive right to enter into commercial arrangements in respect to the works that are created. And the select encoding for the provisions are in table 3 there on the screen. So of particular note is how P1 encoded the provision in one rule and dealt with the statutory text other than a computer program using the not operator, which I'm circling there on the screen. P2, however, adopted a more complex approach by creating 3 rules, 2 of which establish the exclusive right to not apply to a computer program. So while these approaches are both technically sound or valid when using Turnip syntax as the relevant benchmark, the former is arguably more straightforward. And this example highlights that differences can arise even when coders undertake similar training, they use the same language and work in the same team. So after undertaking automated syntactical analysis, we manually cleaned the dataset to attempt to improve the internal consistency of the encoded rules as part of the coding validation process. And we found that these measures improved the baseline average similarity of atoms from 4% to 39% in week 1, and in week 2 from 57% to 84%. And most notably, coding validation measures significantly improved the average similarity of rules from 0% to 16% in week 1, and in week 2 from 1% to 38% in week 2. So these results underline the importance of shared vocabulary, of shared conventions, but also teams having processes in place for managing alternative, technically sound rule structures with a view to reducing interpretive differences down the line. Now, of course, it's important to note that adopting these different coding validation measures can give rise to certain risks of playing with data, including biases and erroneous outcomes. And these risks lead us to explore the importance of interpreters achieving legal alignment between encoded provisions and the statutory text, to which I'll now turn. So as I mentioned above, legal alignment, as distinct from and in addition to coding validation, is vital for ensuring the accuracy and the legitimacy of encoded legislation. And it is a further step in checking the accuracy of individual coding choices that focuses on our interpretation of the provision using a judicially confirmed process as the basis for interpretation. So here we use the modern approach to statutory interpretation. And critically, it is distinct from a claim of legal validity that the encoded rules accurately reflect the law. So we aim for legal alignment as opposed to legal validity. So as noted above, participants encoded the select provisions only, mainly due to time constraints, which means that the legal alignment processes were undertaken by the research team after the experiment. And this subsequent legal alignment process highlighted the complexity of attempting to evaluate the extent to which encoded rules align with the languages and logics of a statute. So to illustrate this point, it's useful to return to the encoding choices for Section 40 of the Copyright Act, for which participant 1 adopted a high-level approach and P3, or participant 3, adopted fine-grain atoms. So this provision, which is one of several exceptions for copyright infringement, establishes that copyright in a work or an adaptation of Part 3 works is not infringed by a fair dealing for the purpose of research or study. And the wording of this provision is significant, in particular, legislature's use of research or study. So this raises the question of whether an interpreter should encode terms conjunctively, as in research and study, or disjunctively, as in research or study. So in the case of Degaris there on the screen, to just as Beaumont stated that terms of research and study take their dictionary meanings and most critically should be considered disjunctively. And indeed, the court considered research or study separately. So this suggests that P1's decision to encode the terms in one atom, so as purpose of research or study, risks deviating from the true meaning of statutory text as articulated by the courts. And P3's fine-grained approach to construing the encoding of the statutory language appears to better align with the court's interpretation of the statutory text. And we only gleaned this after undertaking our legal alignment processes based on the modern approach to statutory interpretation.
Ms. Alice, 5 more minutes, please.
Yes. So just wrapping up to ensure that I have enough time for questions. So I wanted to reiterate several key points from our experiment. So the results of our experiment illustrate the complexities of attempting to reproduce the languages and the logics of a statutory text in machine executable format. So while our analyses are preliminary and we have provided a first of its kind experiment that examines how different legally trained people interpret and convert legislation into computer code, what we've done here is illustrate that an intervention like we had in week 2, which was the meeting during which participants collaboratively agreed on key atoms for manual coding, can significantly increase the average similarity of atoms and, to a lesser extent, those rules. So this finding, among others, supports our hypothesis that coders collaboratively agreeing on key atoms before commencing that coding work can be a very useful thing for rules as code teams. And importantly, can enhance overall the technical coding validation, but also the legal alignment of those encoded rules. So despite these similarities though, we noticed that participants made a range of divergent interpretive choices, which we argue are most likely due to the complexity of statutory interpretation, 2, encoded provisions having varying levels of granularity or fine-grained detail, and 3rd, the functionality of our coding language Turnip. And this underlines that interpretive differences can arise even when coders undertake similar training, use the same language, and also work in the same team. So this further underlines the importance of having established processes and conventions when undertaking this work. And lastly, but most importantly, we contend that rules as code initiatives and teams must ensure that they have processes for both technical coding validation and legal alignment, both of which are critically important in enhancing the accuracy of digitized legislation. And we believe that this is important, particularly in light of well-established statutory interpretation norms and broader public law principles, including the separation of powers. And to ensure that this work is done well, we advocate for multidisciplinary expertise across legal subject matters such as copyright law, statutory interpretation, and technical programming practices. So thank you very much. I'll now hand back to Fernanda.
Thank you very much.
Broader public law principles, including the separation of powers. And
Mr. Guido, I have a question for you from Kevin Ashley. Don't you have to deal with synthetic ambiguity in the legislative text, a la Lehman Allen? How do you address it?
Very much.
Okay, so
public law principles, including the separation of powers. And
am I live now?
Mr. Guido, I have a question for you from Kevin Ashley. Don't you have to deal? I think you have to close your browser of the event.
Yes, so in general, yes, we have to deal with syntactic and grammatical ambiguity. However, in this particular experiment, we haven't had instances, and for a simple reason. First of all, the Copyright Act, it's a very well used and very well drafted piece of legislation. So we didn't find instances. Now, if there are some syntactic ambiguities, it means that then there will be different, possibly different interpretations, and then this will be reflected possibly by the interpreter, and then we will have different encodings by different interpreters. Some of the other questions were one from Mario Bianchi, and it's about the open texture. Yes, it's absolutely possible to model open texture terms, and actually in our encoding practice in the guidelines, we instructed the interpreters, the encoders, to identify such terms, and then there will be some other ways to do it. So essentially, well, either we use an ask a human whether it's true or false, or a third party can create additional interpretation and additional rule set to define such interpretation. Finally, there was a comment by Trevor Ben-Capon, and it was about the study or research. And he mentions that, well, when he was encoding in the early 90s, if they were appearing always together, then they were encoding together. And essentially, yes, it's exactly right. Even for us, we would have taken that approach. However, we had court cases where the court explicitly mentions that they should be treated separately, and that's why we prefer to use the court cases. And also, this is related to the question by Kevin about the syntactic ambiguities. In case there are syntactic ambiguities and you are not able to solve it immediately, you have to consult additional documents, precedent, the answer, the note for the drafting, and so on to resolve the ambiguities. And if it's not really possible, then you will have multiple interpretations. And I think I'm done.
Thank you, Mr. Guido. Now we'll have the streaming of the last paper of this panel. It is called Unreveal Legal References in Defensible Deontic Logic after the streaming. Mr. Guido will be available again to answer the questions.
So this is a joint work in collaboration with Francesco Olivieri at Griffith University. Now, well, this work essentially, it's an extension of what Alice just presented, and essentially it's in the area of computational law. Computational law is the foundation of what we call the ruler's code, and in our view, computational law is just the use of logic, formal model in particular, to first determine what normative positions or obligations, prohibitions, and permissions are in force in a particular situation. And then after we have what are the requirements, legal requirements in force, we can determine whether they have been violated or complied with. And all of these, it can be done by a machine processable, in a machine processable way. Okay, so that it was my introduction, and then we can go to the actual problem we wanted to address in this presentation and with this paper. Typically, the complexity of legal document, it measures in terms of the length of the document, and it has been argued that the use of references, internal references, or references to other part of document, other part in the same document, or to other documents, it's one way to reduce the complexity of the document because they reduce the length of the document. However, there are several problems. First, when you have references, you introduce a level of opacity because, well, you can just see a reference to a section, but you don't know what the section is about, or you don't know what is the content of that particular sections. And on the other side, if we want to encode normative documents, normative systems, taking a ruler's code approach, we have a problem if we use references because they reduce the opportunities to encode or to translate using the isomorphism, the legal isomorphism. The legal isomorphism is that the idea that when you convert a legal document, you want to convert just a part, and when you convert a part and you look at the corresponding encoding, then essentially there are no external dependencies. So if you change text, part of the text in the textual provision, you only have to change the corresponding encoding. But if we have the references and the references must be embedded, then essentially we might lose these correspondence. So, and then essentially here I want to just to give an example of what we mean by legal references. So here I have a few examples. So the important part here is that you can see that there are some references to other clauses. So here, here we have, well, in section 982, we have, well, that's something, it's applicable in section, according to sections 991H, and we have no idea what are those conditions. Similarly, when we look in sections 9.8.2 of the Telecommunications Consumer Protections Code, we can see that there is a reference to something has to comply, somebody has to comply with what's specified in sections 9.9, and then also we will have that there will be exceptions to 9.5, 9.6, 9.7. And when I look here, I have no idea whatsoever on what is the content in 9.9 and 9.5, 9.6, and 9.7. Now, I also have a more interesting case. So when you look here, section 26.105 of the Income Tax Assessment Act, well, as you can see, there are many references. Here we have both external references to a different act. Then we have a bunch of reference where possibly those sections applies in this particular section here. And finally, we have something about failure to comply with another section. So as you can see, references are quite common in legal documents. And if we want to encode those documents in a computer, in a machine executable way, we are able to solve them. Otherwise, we cannot do the encoding and we cannot reason about that. So what is the solutions to do it? Well, the solution is then every time we have a reference, we are going to replace it with its logical representation. So for example, if we have that section 1 can be encoded if A, B, and C, then D, and we have a section 2 saying, well, if section 1 applies, then E, then what we can do, we can represent section 2 if F, B, and C. So we take essentially the logical representation of section 1, and we replace for section 1, and then we include in the other sections. Now, what we have to understand that when we do this manual process, in many cases, we have to do some logical inferences. So here, well, you can see that, well, I have in parentheses, which might be optional, I don't know, I have and this. So do I have to consider D because it's part of the meaning that section 1 applies or not? And in other cases, I have to do more complex reasoning tasks. Well, our solution is, well, we don't want to use, we don't want to replace with a logical structure, but we want to just represent them. So what we do, we start with the feasible deontic logic, and we extend with reference literals. So we will have expression in the language, such as apply sections, complied sections, violated sections, and then the logic is extended with conditions that allows us to determine when apply sections, comply sections, violated sections hold in a particular situation. And then essentially this is what we're going to do in the rest of the presentation. And then if we take this approach here, what we can do, we can just represent, if we take the previous example, section 2, and then we can write in this way. So apply sections 1, then E. And then essentially, we leave the resolution of this condition, of this norm, to the internals, to the logic itself, and then essentially we don't have to perform as encoder the evaluation manually, but then the evaluations will be done automatically by the system. So here is just my used cars salesman pitch for the feasible deontic logic. So it's a rule-based non-monotonic formalism. It is efficient, indeed. It has linear complexity. It has a natural directly skeptic semantics. So it means we don't have to compute all possible extensions and take the intersections. We can do the computations directly. And related to this, it has a natural ability to model exceptions in a natural way, in an efficient way. Also, when we consider the extensions with the deontic component, we are able to speak about the deontic aspects, obligations, prohibitions, and permissions, and violations. But at the same time, we can explain the reasoning mechanism of the logic using an argumentation action structures. But at the same time, it has a constructive proof theory. This means that it's fully explainable, and every time I have a conclusion, I can just provide you the full trace of the derivation. I can provide all the facts, all the rules, all the norms that apply, that are used to determine a particular conclusion. We show that other formalisms often used in AI and law are just variant of the logic and with some differences. And we have used in different fields, and we have a couple of optimized implementation. This in the previous presentation discussed Turnip, one of the most modern implementations, though in some way still partial. And also, as Alice mentioned in the presentation, we've used the feasible deontic logic in several exercises, in several massive scale encodings of acts and regulations. Also, it is extensible, which is a part of what I'm going to do today, and essentially the extension is how to do with the legal references. And also, well, as we know, in most cases, deontic representation suffers from paradoxes, but the feasible deontic logic, for several reasons, something very simple, is not affected by them. So the feasible deontic logic is a combination of diffusible logic and efficient non-monotonic logic for the representation of the exceptions, plus a deontic logic of violation for the representation of the deontic concept of obligation, prohibitions, and in particular violation. And the feasible theory is the way we structure our knowledge, and essentially it corresponds to a set of facts which will correspond to the facts of a particular case, a set of rules, the rules will correspond to the encoding of a piece of legislation, and finally a superiority relation. The superiority relation is an internal mechanism to describe the strength, the relative strength of rules in case the rules are for opposite conclusions and they both fire at the same time. So we can determine that one rule overrules or overrides one of the other rules, and then we can discard one of them. It's just what the language we use, so we just have plain literals or atoms in Alice's terminology in the previous presentation. Also, we have deontic operators, so we can say that something is obligatory, or the negation, which corresponds to prohibition, that something is permitted, and so on. But furthermore, we have a compensatory operator represented in this way, and the meaning is that, well, P1 it's obligatory, but if it's violated, then the violation makes P2 obligatory, and doing P2 compensate for the violations, and then we can apply for all of them. Furthermore, as I said before, we extended with apply, complied, and violated, where R is just a rule label. Well, so I spoke about rules, and then essentially we have two types of rules, if-then constructions. So here we have what are called constitutive rules. Constitutive rules are rules used to provide definition of terms. And the idea is that, well, when A1 to AN also, when the condition to apply the rule hold, then we produce the effect. For a constitutive rule, we have that we provided the definition of a term, while for a prescriptive rule, we have a similar structure. We use the obligation, and the meaning of prescriptive rule is to generate obligations or prohibitions or permissions. So if A1 to AN are the case, so if they are true or they're all in a particular case, we are allowed to conclude that C1 is obligatory, plus since we might have a longer expression with compensations, we can apply those operators and so on. Now, here in this case, we can say that if A1 to AN all, then we have that C1 is obligatory. And if it is violated, so if we have the negation of C1, not C1, we have that C2 it's obligatory and it compensates for the violation of C1, etc. And we can repeat for all of them. Okay, so this is a very basic definition of the defeasible logic, of the ontic defeasible logic. And now we can consider what does it mean to reason in the logic itself. Well, if we want to prove a conclusion, then what we have to do is to give an argument for the conclusions we want to prove. But then we have to consider all possible counter arguments against it. And finally, we have to rebut. And we have two ways to rebut a counter argument. Either we can defeat the counter argument by a stronger one, or we can undercut, so we can show that some of the premises do not hold. So the basic construction is that, well, we can say that an argument is a basic fact, or there is a triggered rule for A, and either all the rules for the opposite are discarded, are not applicable or not triggered, and every triggered rule for not A, it's weaker than a triggered rule for A. So the key point to determine what does it mean for a rule to be triggered. So if we have a rule, and it could be either a constitutive or a prescriptive rule, well, the definition of trigger is very, very simple. We need to have that all the elements in the if part in the antecedent A1 to AN are provable, and that is the basic condition. Now we can start to speak and say, okay, now what does it mean for a rule to be applicable? Well, here we have an assumption that essentially a section corresponds to a rule. It's a big assumption, but it's in this stage because when you really model and you encode real life acts and documents, we have that the sections will be encoded by many, many rules, but we can easily handle and extend to handle those cases. So we can concentrate just to a single rule. Now, here we have two possible interpretations for the meaning of applicable. The first one is that we can say that, well, the rule is applicable. And then in our terms, it also means that, well, the reference applicable are, it's provable. So we can say that it's true. And then the first option is that we just consider the antecedent of the rule, so A1 to AN, so only the condition of applicability. However, if we consider again the first example I gave you, so from the Telecommunications Consumer Protections Code, in that case, a rule is applicable if, well, first of all, the condition, the trigger of the rule applies, so all of them are provable. But also we have that the conclusion, so the effect of the rule, also in the situation or it's provable. And also we can express that using R. Now, here we have a problem because when we take this definition, we have to consider that might be some rules for the negation. And essentially we have to incorporate in the proof conditions, in the derivation conditions, how to consider that there might be some possible counter arguments for the conclusion and so on. And so essentially we have to consider those two options to specify when a rule is provable, and in the paper we did it. Now, what about when we move to defining the conditions when a rule is complied with or violated? Well, first of all, the rules must be a prescriptive rule, and then we can say that a rule A1, AN, prescriptive rule C, it's complied with, and then in the simple case, it's simple. We have that the condition to trigger the rule, the condition of applicability, also are provable, And then, since we want to it's complied, the meaning of the rule is to produce the obligation of C, and then to comply, we have that also C should be provable. And then when we want to consider it's violated, then essentially we have the first condition is the same. We have that we need to be able to prove the obligation of the effect of the conclusion, and also that the opposite of the content of the obligation of the conclusion is provable. Okay, so it seems quite simple. However, what about if we consider this, let's say, this fragment of a license here? So here we have that in some cases, a particular section can include what are the legal requirements, so a prohibition to do something, and then at the same time, they might specify possible way to recover from the violation. So what does it mean to violate or comply with those complex expressions? So when you read this text, it says essentially, well, you have the prohibitions to publish the result of evaluations, but if you publish when you were not allowed, then you have to withdraw within 24 hours. When do we comply? Of course, if we don't publish, we comply. But what about if we publish and we remove it? Do we comply or not? And similar, we can ask the same question for violation. Well, based on the discussions, then essentially we can extend the definitions. And then when instead of a single element in the conclusion of a prescriptive rule, we have a chain considering possible obligation and the possible compensations, then essentially we could have possible meanings. And essentially we have, of course, the rule must be triggered, and then at least the first element must be provable, and additional conditions. In the paper, we really give the proper conditions to specify different alternatives and the different degree of complied with. And similarly, we can do for the notion of provable. Of course, we have to have the opposite, but something more. Okay, so that it was just the idea. So in the paper, essentially, what we did, we studied and defined different types of legal references and how to represent them in the logic. We provide sound and complete algorithm to compute them, and we study the complexity. The key aspect, and well, I don't know whether this is a positive or a negative result, we proved that when we extend the logic with the legal references as presented in this paper, the complexity is still feasible, it's still polynomial, it's quadratic, and then we have an increase because the complexity of the logic when we don't have the references, it's linear. So on one side, we maintain feasible, but we increase, so it's much more. Now, we don't really have any practical experiment to see whether the overhead, the quadratic, the fourth power, it's really a problem or not. I expect probably it might not a serious problem, but it's something we need to study more in the future. So let me go to some possible ideas for future works. Well, we have that references, one of the other possible uses of references is to represent the norm changes. So very often when you want to modify some norms, you specify a reference and how to modify in the particular reference. And in the past, we use nested rules to model norm changes. So what we want to do, we want to extend the framework to model norm changes. And in a couple of months ago, we had another paper where we extended the feasible logic and the computational model of the feasible logic to handle nested rules. So what we want to do is to integrate the algorithms and the computational model presented here with the model for nested norms. Then I said, well, that in real life norms, what you have to do is to consider how to handle set of rules instead of single rules, because, well, often sections reference will be modeled, as sections will be represented by a set of rules instead of single rule. And at the same time, we want to have an optimized implementation. Unfortunately, for some, unfortunate reasons that, the Data 61 terminated research in computational law, it's unlikely that we are going to do in the near future. So, thank you very much for your attention, and I'm open for questions. Thank you very much again.
Mr. Guido, we have two questions for you. The first one is from Hugo Lopez. Thank you very much. We have been working on the problem of references in laws, which in a way relates to the notion of compositionality in both logical specifications and business processes. As you mentioned, sometimes one could substitute a reference by its cousin rules, but in other cases, it seems that some references block executions until reduced. Do you have any thoughts of whether the order of application might need to change?
So strictly speaking, the order of application, it's not affected if you have references. However, some computations might be delayed, and actually this is showed by the complexity, because when we have references, we move from linear complexity to the fourth power. So essentially, we have to run more cycles to see exactly when the references are solved or not. Whether this is a practical problem or not, I'm not really sure, as I mentioned already in my presentation, simply because, if you include the logical representation of the references instead of the references, you still have to compute them first, and essentially you are going to blow up your initial data structure. So I don't expect to be a real problem, and technically speaking, it doesn't affect the computation, even if there is some overhead.
Okay. The second question is from Hilary Smith. For the task of formalizing legal norms, is there any difference in terms of complexity between internal references and external references?
For our method, no, there are no differences. There will be just plain references. There might be some minor concern. One of the concern will be, we don't really know what the external references are. It might be that they might refer to full sections or full parts, or to a complete entire regulation. So from the representation point of view, it will be just one line. From the actual computations might be much worse. When we deal with internal references, we have a much more clear idea about what they are, or at least it's easier because we can check the same document. Now, the problem will be much, much worse if we have to replace them, because in case of the external document, in the worst case, we have to encode the entire external document inside. And for the internal, we still have the problem of the internal references. But for us, it will be, from the representation point of view, it will be just one symbol, one element. From the computation point of view, it really depends on what is encoded in the reference itself.
Okay, thank you, Mr. Guido. Now we are closing the third panel, and right after we will have a discussion about Stuart Russell's previously recorded talk. Thank you.